Welcome to our second presentation on sexual harassment. When we were last together, we had started the process of talking about quid pro quo and hostile work environment. And now we are in this presentation going to drill down into more detail into those elements that we concluded our last presentation discussing relating to hostile work environment. And here we have those elements. Here are the elements. So a little refresher. We need to have all 6 of these in order to have a colorable or a claim of sexual harassment, hostile work environment that will potentially be successful. Sexual harassment has to have been unwelcome by the victim. It has to be based upon the victim's gender. It has to create for the victim a hostile work environment. The action has to unreasonably interfere with the victim's ability to do his or her job. It has to be sufficiently severe or pervasive, or it can be both, obviously. And it has to affect a term or condition of the victim's employment. We're not going to focus too much on items 4 or 6. We're going to focus on the others as we drill down a little bit more. So our first one we're going to talk about is the unwelcomeness. So obviously it can't be a hostile situation if both participants are interested in participating in this relationship. So that needs to be the case. And obviously evidence of welcomeness or unwelcomeness can be both direct or indirect. So here's an example of how that can play out. So initially, Bob and Mary are in a romantic relationship. Bob wants to be in it, Mary wants to be in it. Mary is a supervisor. Ultimately, Bob loses romantic interest in Mary. At that time, Mary immediately stops pursuing the relationship, and they go back to a professional interaction that they'd had before. Assuming that Mary doesn't retaliate in any sense, there is no hostile work environment because the romantic behavior ended as soon as it became unwelcome. So again, we can have situations where things are unwelcome and then become welcome, or start being welcome and cease to be welcome. And the behavior has to be occurring at some point where it was unwelcome in order for there to be a claim. Here's another scenario. Mary's dating Bob, her supervisor. Initially it was welcome. Mary wanted to date Bob, but eventually she tells him, no, I don't want to date you anymore. But Bob doesn't accept no as an answer. He continues emailing her. He drops by her home. He stalks her after work. And again, here we see the work impact. He gives her a poor review, and eventually she loses her job. Under these circumstances, even though it was initially consensual, Mary can claim sexual harassment. Now, sometimes it becomes an issue about whether it was welcome or not, in the sense that a person might pretend that it is welcome because he or she is worried about job security. So he or she acts as if he or she wants to be in the relationship. So let's say Mary had been thinking in her head, boy, I'd really like to break up with Bob. I don't really want to date him anymore. But I'm worried he'll retaliate against me. And so I'm going to continue to pretend that I want to date him. And so he will be under the illusion that I'm still romantically interested in him. Well, what is going on subjectively in Mary's head isn't going to be relevant to welcomeness. If Bob isn't given any indication that Mary has changed her viewpoint, that what was initially welcome is no longer welcome, then Bob obviously can't act upon that information. So when you're looking at these cases, you have to make sure that the victim actually changed his or her behavior in some way to communicate to the person that what once was welcome is no longer welcome. Now, it doesn't have to be a slap in the face or something like that, but there has to be some indication. It can't just be all happening inside Mary's head. And that's one of the reasons why consensual romantic relationships at work are so problematic, because Many times when people are dating, one person is more interested in the dating relationship than the other, and that person may, be looking at the relationship through rose-colored glasses, may not notice the subtle indications that the other person isn't as interested. And so it can be hard sometimes for the person who is no longer interested to communicate that lack of interest, just because you don't want to hurt that person's feelings. Also, because of course in the employment situation, you don't want to lose your job. And so by having a consensual romantic relationship at work, especially between supervisor and subordinate, it's hard for kind of both parties to pick up on the clues that the romance is over. And that's one of the reasons why it's probably a best practice not to go there to begin with. So again, it has to be unwelcome by the victim. And it can't just be all unwelcomeness in the victim's head. She or he has to communicate the unwelcomeness, at least to some extent. The second part has to be based upon the victim's gender, upon that person's femaleness or maleness. Let's pause for a second and talk about, because in the English language, the word sex has two meanings. It has the meaning of procreation, of engaging in behavior that is procreative, we'll put it that way. And it also has to do with the word gender, meaning is a person a male or a female. And when we use the term sexual harassment, we actually use the word sexual in both contexts. Usually we use it for the first meaning, the idea that it is sexual activity oriented. So we talk about sexual harassment, we're typically talking about, people being touched in sexual areas, or people making comments about sexual acts, or people doing things of a sexual nature. But sexual harassment is not restricted to that category. People can harass others based upon sex and it not be sexual. For example, the focus can be on gender instead of sex. And here we have the concept of anti-female animus, meaning this person has negative feelings about women, or it could be anti-male animus would equally work here. They have negative feelings about male. In this sense, sexual harassment is like race harassment or national origin harassment or religious harassment. For example, if I am a Muslim and people religiously harass me, they're not trying to date me. They are angry, wanting to discriminate against me because of my religion. They don't like my religion. And they're angry at me for being part of that religious group. And so there's nothing, it's easy to see the hostility in that situation. There's nothing romantic or flirtatious about that type of religious harassment. Well, it's that same idea we have here when we're talking about gender instead of sex. People are angry at that person for being a female or for being a male in this particular work environment. So we can see it's similar to racial harassment. Let me give you an example of how these might play out. So Bob is the manager. He invariably yells at all of his employees, male or female. He calls them stupid, he calls them idiots, he calls them useless, similar things. Let's just stop the story there. If that's all he does, he's a jerk. And I'm not defending him, but there's no legal claims here. There's nothing here that is discriminatory. He's not treating men worse than women. He's not treating African Americans worse than Caucasians. He's not treating Lutherans worse than Presbyterians. He's not treating people from the United States worse than people from outside the United States. He's an equal opportunity jerk. Again, not at all a good thing, not what we want in our employment situation. Very, very inefficient. But there's nothing unlawful happening here. We're just talking about one of those exceptions to one of those general rules to the employment at will relationship. Bob can be a jerk. The employees can leave if they don't like it. Okay, but that's not where our story ends. Let's continue with the story here. When he shouts at female staff member, he usually uses these words, and I'm sure you can figure out what the words are, that are referring to women in a derogatory way. And in this situation, Mary is one of these women who's referred to by these terms. She files a charge with EOC. Now, Phil, who also works for Bob, is called stupid and idiot or whatever, but he is not referred to with gender-specific insulting terminology. Under these situations, because only women were referred to with these terms, Mary can prevail under a hostile work environment claim, even though Bob is not doing anything sexual. And in fact, I guess you could say this term has some sexual meaning, but this term really doesn't. And so there is no sexual component here. He's not flirting with anybody. He's not making sexual jokes. He's just being mean all the time. But he is being mean in a gender-specific way. So this would be a case of sexual harassment, even if there's absolutely no sexual banter or sexual conduct going on. Here's another example. Mary's the only female security guard with other male guards. Her colleagues verbally harass her because she's doing a man's job. They want it to be an all-men's club. And here are the things that they do. They hide her badge and keys. They put grease on her uniform. They break open her locker and mess up her stuff. Mary complains to her supervisor, who asks, hey, are the men touching you? Are they making sexual comments to you? Well, no, that's not happening at all. Well, the supervisor goes, well, then that's not sexual harassment. I can't do anything. But of course, it is sex or gender-based harassment. So it really is sexual harassment, even though there's no sexual meaning associated with it. Under these facts, Mary does have a legitimate claim for sexual harassment because she's being harassed based upon her gender. And again, we could go through here and switch out female for African American or Hispanic or Asian, and it would be the same type of analysis. Let's look at this scenario. Mary and Bob are both line workers for a utility company. They've been working together for a while. Bob frequently tells her the job is line men, not line woman, and therefore it's not a woman's work. He plays practical jokes on her. He asks her when she's going to get pregnant. He gives her help wanted ads for traditionally female type jobs. If these are occasional things, it's not going to be considered sexual harassment. But if they are very pervasive, then yes, these behaviors can be, especially since they probably work as a team. And I'm guessing if you're line workers, there's some danger associated with it, that both workers have to be in a real trust relationship so that everyone's safe as they're doing that kind of work. And so under those circumstances, yes, I would say that Bob is sexually harassing Mary, even though there is no sexual component to Bob's behavior. We usually think about sexual harassment as something that men do to women, but that is not the only scenario that it can arise. Women can sexually harass men, men can sexually harass other men, women can sexually harass other women. I'm not going to spend time in this presentation talking about sexual orientation and gender identity discrimination and harassment. We'll talk more about that in another presentation. But we are going to talk about sexual orientation harassment a little bit, just because it kind of fits into this larger category. So same-sex sexual harassment is a valid claim, and we'll talk more about it in a later time, but I do want to spend a little time talking about it now. And the big case in this area is the Oncale case, and this is a case from 1986. So it's well before we have Bostic, which is a 2020 case. So we had, over 30 years between these two cases. And at the time of Oncale, if Bostic had come up in front of that Supreme Court, I don't think there's really any doubt that the U.S. Supreme Court would have said at that time, well, no, sexual orientation is not a protected category under Title VII. In fact, if you look at language in this decision, you'll see that the U.S. Supreme Court pretty much dismisses the possibility of sexual orientation discrimination claim. So some parts of the Oncale decision are no longer good law based upon the Bostic decision. But the parts of it that relate to the same-sex sexual harassment likely are good law, at least insofar as they support the possibility of this type of claim. But perhaps a court nowadays might have a more expansive understanding of what qualifies as same-sex sexual harassment than the Oncale court does, because again, the underlying assumption in this 1986 opinion was, of course, sexual orientation discrimination is not a protected category in 1986. Even though the statute itself hasn't changed, again, the interpretation of the statute in Bostic has significantly changed. So again, this case is a little bit problematic because of the evolution of the law. So in this situation, Mr. Oncale, who's obviously a male, alleged that he was sexually harassed by his male coworkers at work. He was working on an offshore drilling rig, and as you can imagine, this environment, especially in 1986, was probably exclusively male, and these men are without they have a lot of free time on their hands because they're stuck out there for weeks at a time. They're not working 24/7, although I'm sure they work hard and many hours, and there aren't, females around. There aren't people they can hang out with and date and do things like that, unless, of course, they're same sex. But these men were typically not likely to be very supportive of same-sex relationships. Anyway, that's kind of, these were men who had a traditional view, typically, of sexual roles and sexual relationships. Anyway, there was some picking on Mr. Oncale. I'm not sure, I can't remember in the story if he was perceived of as being homosexual or if he was perceived of as being effeminate exactly, but there was some teasing, and I'm downplaying it by using those words, but some hazing of a sexual nature of him. Now, I think the men involved would have said that, of course, they were not homosexual at all, but some of the stuff they did was because of sex. And so Mr. Oncale again filed this claim. And the defense that the men alleged was that, well, we didn't experience sexual desire for Oncale. So whatever we were doing wasn't because of the desire to have sex with Mr. Oncale. But the court said, no, it's not necessary that these actions be designed to inflame or satisfy sexual desire. But it's actionable. The claim that Mr. Oncale has is going to be actionable as long as it places its victim in an objectively disadvantageous work condition. And it doesn't matter whether the victim is of the same gender or a different gender than the harassers. It still has to be because of sex. That's still a component. And so, again, the court said same-sex sexual harassment can occur as long as the harassment was because of sex. Now again, because of the Bostic opinion, we're not exactly sure where Oncale continues. So what I used to say about this case before Bostic is that yes, it's possible to come up with a same-sex sexual harassment claim, but unless the person who is harassing is attracted to people of that same sex, it's going to be a difficult claim to make. Obviously, if a lesbian harasses another woman, then that would fall under traditional sexual harassment law. Or if a gay man sexually harasses another man, then that would fall under the same type of legal analysis we're talking about when we're talking about opposite sex sexual harassment. That was, I think, always clearly covered under Title VII once we established that sexual harassment was a covered category. But and here we have a situation where we have just that issue, where we have a gay person who is sexually harassing. So John is an openly gay man. He's constantly teaching his coworker Paul, telling Paul that Paul should come out of the closet. John has said that he finds Paul sexually attractive, even though Paul has said don't make these comments. So Paul is saying these are not welcome. Even though Paul and John are both men, Paul very likely has a claim of sexual harassment if this behavior on the part of John is pervasive. We would all agree, even before Oncale, we would all agree that this was a scenario where you could have, because again, John's behavior was motivated out of sexual interest, the classic scenario for sexual harassment. So we do need to have it being based upon the victim's gender. It has to be unwelcome and based upon the victim's gender. Now we're going to look at the third requirement, because again, these are all ands. We need this one, and we need this one, and we need this one. We need that the plaintiff needs that the actions create for the victim a hostile or abusive work environment. So let's see what we mean by that. How do we decide whether it's crossed the line? You know, we've talked about that continuum, and each little step maybe gets us closer, but when is one step too far? How do we decide, oops, it was okay up to this point, maybe not okay, but at least not unlawful and didn't violate Title VII, but now we've crossed the line. Where is that line? Well, here are some factors to think about when you're trying to decide where that line is. So we're going to look at the frequency of the behavior. If it happens only occasionally, it's going to have to be very severe. If it happens very frequently, it can be significantly less severe. So it's a combination. You know, if you think about scales, you know, where you're managing the balancing act, where you have, you know, a little basket here where you can put the events, so to speak. Okay, might just have a few events. Well, if they're very weighty, then that will tip the scales down to here. But if there's only a very few and each one is relatively trivial, it's not going to weigh it down. That's the idea. Then, of course, severity. And things can be so severe that even a single instance can be sufficiently hostile. In the sexual harassment area, it could be a groping or obviously rape. It could be, if we're talking about a different type of harassment, such as race harassment, it could be a physical violence, or maybe a noose left in a provocative way that becomes a threat. So things can be, a single incident can be so severe that you don't need frequency. It doesn't need to be physically threatening or humiliating, although obviously if it is either physically threatening or humiliating, then that obviously means it's quite severe. But it doesn't have to have those characteristics. Whether the offensive behavior unreasonably interferes with an employee's work performance is a key factor in this analysis. Let me flip back here. So these two are very much connected to each other. I have them listed separately because they usually are listed separately, but I think the analysis flows very nicely between the two. This is one of the reasons why I don't have a separate slide for this one. So if you're able to conclude that the behavior does unreasonably interfere with the victim's ability to do his or her job, then it's a pretty safe bet that it is causing the victim a hostile work environment. Now we've gotten to our second case. We talked about Meritor Savings. Now we're up to Harris. This is, I know we had the Schmitz case, but that one was just kind of give you an example. That's not an important case. But this is an important case. And usually people call this case Harris. You will sometimes see described as Harris versus Forklift Systems. Harris is not a tremendously uncommon name, and so sometimes people like to include the second name just for clarity's sake. I've never heard people refer to it just as Forklift Systems. You always hear the Harris in there as well. And you can see that we have almost 12 years from Meritor Savings until Harris. And so during those 12 years, we knew that there was a hostile work environment sexual harassment claim that was possible, but we really didn't know exactly what that ought to look like. And so you can see how that could be kind of an unsettling time period for both plaintiffs and defendants. But Harris did help us resolve many of those issues. So you need to know the name of this case, its significance, and the holding. And so let's look at the issue that Harris was looking at. Must sexual harassment seriously affect an employee's psychological well-being in order to create an abusive work environment that violates Title VII? And the answer is no. So the person doesn't need to have had some kind of psychological breakdown or be mentally ill as a result of the circumstances. That's not what happened to Ms. Harris, and she's still able to assert her claim. So it isn't quite as severe as perhaps some people, it doesn't have to be quite as severe as perhaps some people thought it had to be under meritorious savings. You may recall in the meritorious savings case, the victim, Vincent, had to take off extended period of time from work, presumably because of mental health issues. And of course, the behavior that was alleged against Vincent was very, very egregious. And so some people thought, well, it really is just for very extreme cases where there is just really, really extreme behavior and the person is mentally or emotionally very, very affected by those incidents. But Harris tells us, no, that isn't the standard. It's not that high. So let's consider the holding in this case. The court found that the Supreme Court had been wrong to focus on whether the harassment had caused concrete psychological harm. Instead, the test should be whether the conduct was hostile or abusive. So we're focusing upon the conduct of the alleged harasser, not on the particular subjective interpretation of that and the repercussions for that interpretation for the sake of the victim. So we're going to look at the reasonable person. How would the reasonable person have considered that circumstance? Not so much how this particular person was affected. So if the environment would reasonably be perceived as hostile or abusive, then there's no need for it to be psychologically injurious in order for the person to assert the claim. But we do need two levels here. So we have the objective, the reasonable person standard. Was it reasonably perceived? And then we also need the person who actually is filing a lawsuit to have perceived it that way. And again, in some sense, this goes back to the welcomeness. You know, if I'm not bothered by the banter, maybe I don't particularly like it, but I don't mind a few dirty jokes. It doesn't affect me. Even if it might affect lots of people, I'm not going to have a claim for sexual harassment. Let me give an extreme example. And I don't mean this in an offensive way, but let's imagine that we have somebody who's led a very sheltered life. We'll say that she is an Amish person, and she's left her community to get a job working in a warehouse. She's never seen a dirty magazine. She's never watched cable. She wears, very modest clothing, and people in her community, people she interacts with, all dress very modestly. There are no off-color jokes. She's led a very sheltered life. She is unusual in our culture for having led that very sheltered life. She works in this environment, and yes, there are some sexual comments, and there's, a Playboy picture posted a couple of places. But most people would look at it and go, it's a warehouse. That's kind of how people act in a warehouse. It's not sexual harassment. No comments are being made to this woman. It's all pretty tame stuff. And so objectively, it's not sexual harassment. Now, she may perceive it as being very disturbing and very upsetting. And she's not wrong to feel that way. That's just her subjective experience. So I'm not saying she's wrong, the culture is right, or the culture is wrong, and she is right. She's satisfied this component because she's very uncomfortable, very stressed about working in this environment, even though to the average person, it might not be any big deal. But we need to have both components. It needs to meet the reasonableness standard, and it has to be subjectively for that particular victim to be considered hostile or abusive. So we need to have both the reasonable and the individualized perspective. And again, here as we have for most of our U.S. Supreme Court cases, you have the ability to listen to a 3 or 4 minute summary about the case. I encourage you to listen to it because these can be very helpful in understanding kind of where the court is coming from. So this is an interesting issue. Some courts like to focus on the reasonable victim instead of the reasonable person. And this is kind of a fraught area of the law. It's somewhat unsettled. I think people in the Me Too movement were really encouraging people to move to the reasonable victim model. And the idea here is that The reasonable person is neither the perpetrator, the alleged harasser, or the victim. You could say the reasonable person is the reasonable fly on the wall, the reasonable person observing this interaction. And how would that person feel? Well, many times people feel that that basis, at least in our culture, typically becomes male-based, that it's focused on our male value. It doesn't have to be, because obviously half of the people and half of the flies in the world could be female, but it is viewed as somewhat more leaning towards a male perspective, and therefore maybe not as sensitive to the perspective of women. So some courts have said, well, let's look at it not from the perspective of the harasser, not the perspective of the fly on the wall, but let's look at it from the perspective of a reasonable victim. Not the super sensitive victim, you know, the Amish person, not the incredibly comfortable and laid back victim, the person, you know, who thinks those jokes are funny or is completely unaffected by the jokes and things like that, but the typical victim. So far, I would say that where we are is more in the reasonable person category, especially in the Fifth Circuit. But this could be an area of the law that we see a movement from reasonable person to reasonable victim. It's just hard to say right now where we're going to end up. And again, here's just a definition. If we're a reasonable person standard, we're viewing the harassing activity from the reasonable person in society at large. So the jury gets to say, well, if I had been present in the room, what would I have thought was going on? The reasonable victim, we're looking at it from the perspective of still a reasonable person, but the reasonable person who is experiencing the harassing behavior, and also considering gender-specific, sociological, cultural, other factors. So in this situation, what we're asking the jury to do, if the reasonable victim standard applies, is saying, well, how would I have felt given this victim's life story if I had been that victim? And so again, in that situation, that Amish person who comes from a different culture, a different sociological situation, we might say, you know, the reasonable Amish victim standard or something along those lines. So it's going to be a more specific, situation-specific analysis before we're deciding, because again, we need to have both satisfied. We need to have the objective standard and the perception standard. But here we're moving the objective standard to a more specific center. We're looking at the victim, not at the overall view of society. So it'll be interesting to see how those areas evolve in the coming period of time. Again, it needs to be sufficiently severe or pervasive. We've already talked about this a little bit. And again, here's our definition. Harassing activities that is more than an occasional act or is so serious that it's basis for liability. Again, deciding when you've crossed the line into severe can be problematic. One of the things that I have seen in when people are talking about this sexual harassment in the culture is that usually people don't put as much weight upon the need for it to be severe and pervasive as the courts have. So a single joke that is offensive isn't going to be considered severe and pervasive unless it were, say, physically intimidating or something like that. So a single joke isn't going to cross that line. You usually, again, unless you have a severe one-time incident, you're not going to have this with just a one-time event. Already kind of talked about this difference. So Bob occasionally compliments his secretary by saying, "You look nice today," or "That's a pretty dress." That's not going to be a problem. That's not even going to get on the radar of an event that could be sexually harassing. So we don't need to consider how pervasive it was. In this scenario, though, so this is just not even, this is in the green area, completely green. So Mary, Bob's voice, has been asking Bob for sexual favors. She instructs him to meet her outside of work. She touches him inappropriately. She promises a promotion if he will be sexually intimate. He succumbs, he gets the promotion, but afterwards, he refuses to continue. She fires him. And that situation is just quid pro quo, because we don't even have a hostile work environment situation here. She says, have sex with me. He says no. She fires him. There is that tangible job action. And so we don't need that for it to be pervasive. We don't need all of these elements that we've talked about. We don't need these when there's quid pro quo. Only in a quid pro quo situation do we need those. So Bob and Mary work in the same department. On Mary's birthday, Bob stops by her cubicle, gives her a cupcake, and asks her out to dinner. It's a large department. They've never spoken before. Mary thinks Bob's kind of weird. Why are you asking me out? We've never spoken before. So he declines. Bob doesn't do anything else, but yeah, Mary's kind of creeped out by the experience because, I mean, she does see him around the office. She's like, oh my gosh, what's going on here? But under these facts, Bob hasn't done anything wrong. He didn't know whether it'd be welcome or not. So, you know, the first overture somebody makes, even if it violates company policy, if there's a no dating policy, isn't going to be sexual harassment because it's possible it's going to be welcome. I mean, it's possible Mary would have said, sure, let's go out. And so that first overture can't be sexual harassment. I mean, unless it's, you know, grabbing her or something like that. But if it's asking her on a date, it's not possible. Now, if Bob's asked her out on a second time after she says no, that's when you start having the possibility of it being sexual harassment because Bob has some reason to know that it might be unwelcome. So we've talked about all of our characteristics. It has to be unwelcome by the victim. It has to be based upon the victim's gender. It has to create for the victim a hostile work environment. It has to unreasonably interfere with the victim's ability to do his or her job. It has to be sufficiently severe or pervasive, and it has to affect a condition or term of the victim's employment. And so we've talked, this again all has to do with hostile work environment. We talked earlier about quid pro quo. So we've talked about both of our legal theories for harassment. Before we go on, though, I'm going to talk briefly about the idea of how we decide who to believe, because, you know, the whole phrase he said, she said, literally is talking about sexual harassment cases. It's very common for the alleged harasser to deny it. Sometimes he or she's denying it because he or she is telling the truth. Sometimes he or she is denying it because he or she is worried about job security or maybe his or her marriage or something along those lines. And so deciding who to believe and how to evaluate the evidence is a very, very important factor. It's important for the jury, but it's also important for the employer because in many cases, the employee is coming to the employer with this, the victim is coming to the employer with this allegation. So of course, one thing that the employer needs to look at is the inherent plausibility of the witness's statements. Do the stories make sense? Which one makes more sense? Then the demeanor of the witnesses. Who seems to be telling the truth? Also, the witness's motives to falsify. Certainly it's obvious why the harasser would want to falsify, but it can also be the case that the victim wants to falsify. Maybe the victim thinks that, or the alleged victim thinks that he or she's about to be fired for another reason. Well, having a sexual harassment claim pending can be perceived as an example of job security. So looking at the whole story of the motives can be an important part. Then looking how you can collaborate the statements. Were there other witnesses? Were there, if the events relate back in time, did the victim tell contemporaneously other people about what was happening? Emails, telephone records, things like that can also be powerful sources of information. Has the harasser done similar things to other people? Maybe there can be other people who can talk about that behavior. Has either person had a history of being untruthful? All of that can be relevant as well. So these are some examples of things to look for as you're trying to determine who is credible. So at this point, we've gone through the introduction to sexual harassment and we've talked about the legal theories, quid pro quo, and hostile work environment. In another lectures, we're going to talk about the employer liability as well as tort and criminal claims. I hope that this presentation has been helpful for you. As always, if you have questions, please don't hesitate to stop by my office hours so we can talk about them in more detail. I thank you for your attention and have a wonderful day. Take care.